particular to the site development because I'm looking at and I said, you know, when I did that, I did a job for you after Johnson. It's just so old.
There's not near as many loops and
And layers,
or,
right?
yeah, typically
So I guess
100%.
there were a little, I think there's a little learning curve with him
For them,
in
yeah,
Florida.
I'm sure, I'm sure. And he's got a lot more meetings maybe to get to, that kind of work. Yeah, it is totally different ballgame.
It used to be a lot harder here.
Of course it does.
Governor Chris, no, not Governor Chris, Governor Scott
Yeah.
released a lot of those regulations that we used to have.
Oh, really? So you used to get you called.
Yeah.
Right, this is-
Yeah. Oh, yeah. It's simpler.
Yeah, we don't have future land use in Georgia. I mean, very rarely. There's a few, cities or counties that may incorporate
The meeting of the Escambia County Board of Adjustment, October 20, 2021, is hereby called to order. With 6 members present, we have a quorum. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualification and abilities to offer expert testimony? Seeing none. The BOA meeting package of October 20, 2021 with Development Services staff's findings of fact has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence.
So moved.
Have a motion by Judy. We have a second.
Second. Second.
Second by Willie. Those in favor signify by raising your right hand. Motion passes unanimous. Do we have proof of publication?
Yes, sir.
And did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
So moved.
Motion by Judy,
Second.
second by Willie. Those in favor of the motion, please raise your right hand. The motion passes unanimously. Members of the board, have you reviewed the resume and transcript of the Board of Adjustment meeting held on September 15, 2021? And I believe we can do the September 2021 simultaneously. Upon the review and the resume of these, this transcript, are there any additions, deletions, or corrections?
I have one correction.
Yes, sir.
On the September 20 meeting minutes, it's indicated that today's meeting was to be on Monday, October 20, instead of Wednesday, October 20.
If no objections, that correction will be made to the minutes. And we're approving September 15th and September 20th. Do we have a motion?
So moved.
Have a motion, motion by Judy. Do we have a second?
Second.
Second by Marty. Those in favor signify by raising your right hand. Passes unanimously.
The Board of Adjustments, the BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, Unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decisions by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. The first case is conditional use 2021-15, 7100 Highway 97. Board members, has there been any ex parte communication regarding this case? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself at this time, state your name and address for the record, and be sworn in by the clerk.
Good morning. My name is Alara Mills Gutcher. I'm a certified land use planner. I'm considered an expert and have been accepted as one at these hearings before. 2311 Lee Street in Lynn Haven, Florida.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good
And
morning.
you were provided a copy of staff's findings of fact.
I was, thank you.
Okay, would you like to comment?
Yes, this is an application. You want me to present first, Caleb, or do you want to? Okay, thank you. This is an application for a site considered to be in the Walnut Hill area on Highway 97. This is for a retail store which will exceed the maximum square footage allowed by right, which is 6,000 square feet. We need a store, or the prototype for the store that we would like to develop is 10,640 square feet. Just recently this year, your land development code was amended to allow an increase in size for a conditional use to up to 15,000 square feet. And we want to thank Commissioner Berry for helping us with that and getting that increase for these types of stores, because actually your conditional use and your use by right were the same square footage, which didn't make much sense. So now we are applying for that increase in size, and that's the only request that we're asking for today, is that increase in size. The property is considered rural community on the future land use map and rural mixed use on the zoning map. We are not asking for anything else. As I mentioned, we will meet all other requirements of the land development code. The site is about 4 acres. We did notice when we were running through our analysis that there is a discrepancy between the property appraiser's data and the survey that we had conducted. So if you look at the figure 1 in your packet of the conditional use application, you can notice that there are 2 boundaries there. One is the red outline and one is the yellow outline, and we are only requesting for the site that is in the red outline, which is about 4 acres, a little bit more than 4 acres. Both of the future land use category and the zoning category allow for this type of neighborhood serving non-residential use, and meets the requirements otherwise of Section 3-2.4, Part C, Part 2 of the Land Development Regulations. Just as some history, we did hold a meeting earlier this year. We were trying to recall the exact date, but sometime in February with the neighborhoods up there in the Walnut Hill area to discuss the location of a retail store such as this. The overwhelming response was that they were very ready for something like this, as they mostly have to drive up into Alabama to get daily groceries, and that something more convenient to their homes in this rural community was desirable, and they're really excited about it. And the other conditions I have included in your packet are some compatibility analyses that are in the last sections of the compatibility analysis that I presented to you, and shows that this use will be compatible, especially due to the size of the property. We're able to put additional setbacks and the buffers to include that against the residential uses which are existing specifically to the east. So I would stop there and just request that you help us approve this application so that we can move forward with this development and serve the community with daily necessities and some grocery up there.
Thank you very much. Board members, any questions of the applicant?
I've got one. Is this about the same size as all the other Dollar Generals that are being
Yeah,
built?
they're typically 10,640 square feet, yes. Sometimes they construct a little smaller, but this one will be that larger size.
Board members, would you like a presentation from staff in that they have accepted the findings?
Mr. Chairman, I think that would be a good move, in my
Okay,
opinion.
staff would do a presentation, please.
Certainly. Caleb McCurdy, Senior Planner, Escambia County. Here we have a location map showing it at Highway 97 and Highway 99. This is our 500-foot zoning map. The zoning is rural mixed use. Future land use map, RC, a rural community. And here's an aerial map showing the location of the property, the intersection. This is our public hearing sign looking southeast along Highway 97. This is looking north onto the site. And this is looking somewhat northeast onto the site. And this is looking northwest along 97 and looking across Highway 97. If you'd like, I can go into this findings. If you have any specifics, I can go into the individual criteria. I would say that we found that it did meet all of the criteria. If you need any details on that, I could go through the findings if you request it. The main thing about this I would note is that this is, as Ms. Laura alluded to, this is allowed by right in the zoning district of RMU, meaning that the location criteria and the compatibility that we really look at, you know, with planning board stuff and the commercial uses, it meets that. The classifications of roads, being Highway 97 and 99, allows for retail sales. And straight up, you go, we wouldn't be here if it was less than 6,000. So the need for the larger store as their model and things like that, we found that it can meet those compatibility and otherwise would be allowed. It's just for the larger store.
So it looks like there's a couple houses on the property. Are those going to be demolished and,
I think there were some property line boundaries that the applicant probably can allude to. I believe the overall aerial may have shown a house, but I don't believe it actually is.
So You're correct. According to the property appraiser's data, there are 2 houses, but that was where that discrepancy is. There's actually only 1 house on the property, according to the surveyed site, and that will be removed. The other house that's on the east side actually is not part of this 4 acres. There was a discrepancy on the property boundary, so that one will not be impacted.
Are there other homes, looking through the photos, that will be near this store, proposed store?
Laura, I could answer that if you want. We did provide in our findings, when we looked at this, there's an exhibit, Rachel can pull it up, showing the surrounding uses abutting the property. So we found that to the north there, we have a single-family resident, SFD. On to the east there, as Ms. Laura was saying, there's one there across the street. And we found that there's some type of farm supply / retail that is otherwise across the street of 97, and up to the back is timber. So those would be the surrounding uses we found just in that vicinity.
So primarily then, we're not facing a situation where this is going to be adjoining a number of residences then? Is that what you're saying?
Not that we found. I would state that buffering would be required. It is going to be required per the development review process, and we'll ensure that it meets those standards once the application is filed and reviewed.
Also, in the past, and I guess this probably is your question, I suppose, in the past, if my memory serves me right, the store that we approved for Cantonment, one of the requirements was, and I think it was on Gulf Beach Highway also, but that's not Gulf Beach. It's obviously not the same situation. The one in Cantonment was going to be constructed with the wood or fox wood kind of facility. Are you going to do that here?
So I'm going to defer to Buckley, who is actually representing Terramore Development. That's the company who will build the structure. But do you want to speak to that, the architectural?
Hello, my name is Buckley Davis from Terramore Development.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Thank you. So the wood prototype that you're referring to on Cantonment is not what we have planned for this specific site. It is something that we could look into. Our building design is all over the place right now with the way the building material shortages from COVID and labor shortages in the construction or I guess supply industry. Definitely something that we could look into. I do have some pictures of the rendering that we are proposing for this store if you guys would like to take a look at that. It is upgraded beyond our basic prototype. We'll have some nice hardy board paneling along the side. I was talking to Mr. Horace about potentially adding some shutters to the outside of the building. The biggest thing here is we want to preserve that small town community feel and have a good looking store.
That was my concern. You understand that our code tries to protect as much as possible agricultural lands in the northern part of the county, which are rapidly, in some cases, disappearing.
Yes, sir.
And that was the reason that I was a little concerned. In other words, I'd hate to see a steel kind of construction facility being built. To my mind, that would be out of character for what we're trying to do in this area to preserve the rural flavor or look of this area.
Yes, sir, absolutely. I couldn't agree with you more on that. And so I can assure you that we will work with staff in the county to present a good, farm type looking design for this store. It will not be our typical prototype, just metal building.
Okay.
And I do have some pictures that are, it's
Yeah.
preliminary that I could
Mr. Chairman,
have you
I-
pass around.
If it's, the board would like, I would be interested in looking at the pictures and perhaps taking them into evidence.
Sure. Do you have them that you could pull up on the screen?
I have them printed out, if I could just pass them out.
If you
Okay.
guys-
And I apologize for not sending those over sooner. This is something that was primarily discussed in our community meeting back in February with the Walnut Hill community and residents, and it seemed to be a design that they liked as well. And again, there is some room for us to maybe add a few things to
To be
create
on
that.
the safe side, the chair would seek a motion from the board to admit these photos into evidence. Do we have a motion to do that?
Motion to submit the photos.
Motion.
I'll second that,
And
Mr.
a
Chairman.
motion by Willis, second by Michael. Those in favor signify by raising your right hand. Passes unanimously. If you would show us the photos.
Yes, sir.
Thank you.
Have you had any contact with, there are apparently a couple of homes that are nearby. Have you heard from those individuals?
No, sir, not directly. So the home that's directly adjacent to the east of our proposed site, there's actually currently no resident that lives in that home. Our sellers actually maintain that home, the lawn outside of the home and the home itself it was one of their old friends, family friends, I think, who has since deceased. And the house now belongs to their family, but nobody, to the best of my knowledge, nobody currently lives there. I approached it.
And I just want to go on the record to reiterate that this is just still in draft form, these architectural photographs. That because of what Buckley mentioned about the shortage of supplies and delivery issues, that, months down the line when we get ready for construction, there might be a change of plans.
And Buckley, if we could have them for staff. Can we
Yeah,
have one of the
come-
photos?
Appreciate it. Welcome. Thank you.
And what, you have, of right, you can build up to 6,000 square feet. And you're asking for essentially 4 more. What is the reason that you need the extra space?
Dollar General just doesn't have a prototype or store model size as low as 6,000 square foot. 6,000 square foot, believe it or not, is not a lot of room to work with. That's more so the size of a really small convenience store, or maybe a mom and pop type shop. So it's, unfortunately, we just don't have a model that small that we could make work in these areas. Also, to expand further on the 10,640 square foot model, Ms. Judy asked earlier if that was kind of our typical prototype size and store model for Dollar General. The old model, the more typical model that you've seen probably over the last few years was a 9,100 square foot model. The recent increase in size has been to accommodate more frozen foods, fresh groceries, where we've been asked not to promise fresh produce because logistically it is kind of hard to do in some of these more rural areas. But this store would definitely fit the bill, where they would try to get some of that more fresh produce, fresh grocery type product in the store because a lot of these residents need access to those type foods and groceries.
So this will have a larger offering, is what you're saying?
Absolutely.
For the people in the area?
Yes, sir.
Okay. I guess I have a staff question. In your analysis, you found that this is compatible, and you were of the, not you personally, but the department is of the opinion that if we approve this, that we will not in any way be disturbing our goal of trying to protect agriculture and silviculture in the northern part of the county.
Yes,
which
sir.
is the last real rural area that we have now, and
Absolutely. That was definitely looked at. In the RMU zoning district, the intent and what you're referring to, it refers to prime farmland. And it goes into the sites that are gonna impact, I think it's 50% or, sites over 10 acres. None of that applied to this particular site. This site was 4 acres. So we found that impact on prime farmland, as you're referring to, and what the RMU intent is protecting, didn't apply. So if we were dealing with a 20-acre parcel and they were proposing to cut out an acre to build this thing on, we would have looked at that a lot more, and it would have definitely affected our analysis. But we looked at that and found that didn't apply, and that all the other criteria were otherwise met. We did see that, a little bit more buffering was going to be provided. It's not going to be right built up to the road. The setbacks in the zoning district is 40 feet from the property lines from front and rear. But yes, we did look at the impact on the prime farmland and those agriculturally protected lands. Again, if this was on a larger piece and they were going to develop a corner of it, that would more than likely apply and be heavily weighted in our review. But we found it didn't necessarily apply in this situation. Due to the size of the lot, it was already a lot of record and things like that. So it just didn't factor in on that.
Has staff checked for heritage trees?
We have not. We hope that at the time the developer is going to provide us with a tree survey and those applicable things at the development review process. And definitely if there's something of that nature, we would definitely require protection and or mitigation and review at that time.
it appears that the lot is wooded, a good portion of it from the aerial.
Yeah, and I can't verify the size of the trees on there. I wish I could say that, what size were out there. All I could tell you is that, we hope that all the trees are protected. And if the ones that are proposed to me removed, then they would need to mitigate per the code.
Board members, any questions of staff? Or any questions of the applicant?
You did say you will look at having a building with more rural character.
Yes, sir.
I mean, that's important, at least to me as one board member.
Absolutely. And I don't, if you want us to coordinate with you directly, I know I had
No,
a brief conversation with Mr. Horace earlier, and we had already planned to do that through the development review process.
And you are going to heavily buffer this area.
Yes, sir. It's gonna have, we have a 16-foot landscape foot buffer on the east and north side, and then we'll also do additional privacy fencing along the eastern boundary to make sure we shield that neighboring residence from our development. And we're also gonna try to leave as much natural buffer as we can on all sides of the property. We're using a very small portion of the property. It just happened so that the parcel was just over 4 acres.
And there are no stormwater issues or anything like that?
No, sir, not to our knowledge.
And let me say something. To be clear.
Mr. Horace, have you been
Yes,
sworn?
sir, yes, I have.
Yeah.
I've been sworn in. I mean, on stormwater, staff will review any of the stormwater issues. I don't want to put on record, so there's no stormwater issue, then we come up, then there are some more significant things that we have to address. So at this point, staff will definitely review stormwater accordingly, and if there's anything that need to be addressed accordingly, they're gonna have to do it. That is a mandatory requirement within our land development code for stormwater. And all of those provisions and land use regulations.
Thank you. Any staff have any closing remarks they'd like to make? Does the applicant have any closing remarks they would like to make? Then the chair will now entertain a motion regarding this item. In your motion, please state whether you adopt staff's findings of fact. If for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur. Do we have a motion?
I make a motion to approve according to staff findings, and I don't have anything else to add.
Second.
Motion by Willie, a second by Judy, that we accept staff's findings of fact and based on approval of the receipt of the development order through the site plan review process. Any questions? Those in favor signify by raising your right hand. Passes unanimously. Thank you all very much. I think we have a business item or so that we'd like to discuss.
No, not at this time.
Mr. Chairman?
Yes, we do.
Yeah.
Mr. Godwin?
Mr. Chairman, I guess this is under the lessons learned category from our last hearing. I'll be honest with you, was a little bit concerned that we had a person or party that wanted to or did file motions without being formally admitted as an intervener. And I think that that's just not correct. And I would just hope that we would not have this occur again, because technically that party wasn't a party to this proceeding. They were a party to the, of course, to the other proceeding, but not to the matter that was before us. And it's just bad procedure, in my opinion. And I would just hope that we wouldn't have that again. And I'm not, of course, you never say never, but I would be disinclined to support any kind of application from a person who wished to intervene if they have already presumed to file motions and make argument before they actually are before us legally. That's my concern.
Kristen?
Well, the board did vote to allow the party to. The board voted to allow the party to intervene. And as I said at that time, it would be ill-advised to not allow the property owner to intervene in an administrative appeal where their development order was in question.
That's not, and I agree, you are correct. But my point was motions were filed before we allowed the intervention, and that's wrong. And I think it disrespects the board on top of that.
I suppose, would you have preferred that they first filed a motion to intervene and with
then,
their motion
yes.
included a motion to dismiss?
I mean,
these kinds of rules aren't fleshed out in the Land Development Code, and there's also not a filing deadline for an intervening party in that circumstance. So this is a quasi-judicial proceeding, and it's.
But that's pretty standard in any. You wouldn't go to court and start filing documents and motions and stuff if you weren't a party. Am I?
This is a quasi-judicial proceeding, and you know, you are not strictly governed by the rules of civil procedure. And, you know, whether right or wrong or indifferent, the board did ultimately allow the party to
Yeah.
intervene. So
Right, we
that's all I'm
we
saying.
did that, and that's not the point I'm making. The point I'm making is that documents were filed, motions were filed before that was a stranger to that particular controversy. I'll admit, not to the overall controversy, but to that. And that's just wrong, and it ought not to happen.
Well, I suppose the alternative would have been for the intervening parties, counsel to show up at the hearing. I
And-
think he was
and
trying
ask
to give
permission.
advance notice, or he could have filed the motion to intervene in
Right.
advance as well. I'm certainly not defending the action that was taken. I just, you know, there aren't any rules that stated in the Land Development Code that dictate how an intervening party may actually present themselves, so.
Does that mean that staff could reject prior to the board meeting?
No,
And
no, that would not be staff. I wouldn't recommend that staff take that step. That would be
It's a
something
board-
the board needs to determine. So, you
Well,
know,
and the problem, I agree, the problem we have is, we don't, unless we listen to them, we don't know what their standing is. And if we listen to them, then we end up with what we had on the 15th.
right,
or the
and
20th,
I
whatever.
think you handled it as well as you could have. Procedurally, it was a bit jumbled, and, you know, that's the way it was presented. It's very rare that occurs, but in that circumstance, as I said, I think it would have been ill-advised to not allow the property owner to intervene and be a part of the proceeding.
Oh, we're not talking about the property owner, we're talking about the group.
Mr. Hoffman was representing the property owner who was the one that received the development order. That was the subject of the administrative appeal, of both appeals. So in the future, you're the board, however you wish to handle it. If you want to first ask that party make a motion
To be admitted.
verbally to be admitted, you may certainly do that. Ultimately, the board took the action to allow them to. So, you know, that's up to you.
Chris, I have a question on, because if that's, I think we gotta be careful, and I'm thanking you, Christian, for this question. I don't want us to be setting precedents that may get us in legal jeopardy in the future. If that's the motion going forward, if that's the action going forward, if the board's so inclined to do that, what would be the reason to deny an applicant who asks for intervention? What would be the reason, board, that you want to deny someone from intervening in the behalf of a client whose property is under review? So, and then that may give more grounds for other legal questions from the second court. What would be the ground? We don't have those procedures in place, and I would really want to have, if that's the design that y'all want to put forward, then we really need to have more legal direction to what would be your grounds to deny it.
Well, Ms. Jones,
And
not
intervention.
necessarily to deny it. The problem, the legal problem, of course, I'm an old lawyer and well past my prime and not, I'm sure, as skilled as our counsel. But the point of it is, you had, I'm not saying deny the applicant. What I'm saying is, I think it's improper that the applicant was allowed to file motions in this particular case when they were not a party to it. Now, if they had shown up and asked for permission to be allowed to join the proceeding, then that's fine. I mean, I don't have a problem with what happened in the end, my problem was how we got there, that it was just improper for them to file things when they were not legally a party to the proceeding yet.
I don't know that I would want to burden the clerk of the board with deciding who can submit something before a hearing, a public hearing. Now, whether or not you all wish to, as a procedural matter, before allowing an intervening party to speak and make arguments, request that they be allowed to intervene, I think that's perfectly fine. But
That's where I'm
if they
going.
wish to submit something, whether you wish to consider it before the hearing and before they have been granted a motion to intervene, you know.
Yeah, that would be, I agree, that would be rather challenging for us. If they submit paperwork, then we gotta say, well, make the decision, not just submit. I'm telling you right now, respectfully, that could cause my department more challenging, so I think we need, I would really depend upon the legal counsel and direction on how, if that's the desire, get something laid out legally, because so we would not be using a subjective point of view on what to accept, what not to accept. I think that'd be problematic for my staff, honestly, because this is the quasi-judicial board. This is what everyone, if they have concerns with what we do, basically this is the hearing before it proceed to the circuit court. And if it's not, if we get all filed up here, there's no way we're going to win on that aspect of it. So procedures, policies written, that's my concern, that I want to be very careful. And when we start saying things that are improper, people take what this board say as being, in my department, they take it as being so, whether it's one or two, as, I hate to use this term, but as being locked in stone. And so that's why these discussions, they need to be really laid out, written, so we can really know what to follow to protect this board, and we got a good attorney, because this is the next step for the circuit court. And then we can get all messed up, and then that's the issue, and put the BCC on more of a challenge.
Let me ask you this. My problem was not with the appeal, but that person, we asked over and over again, we were chasing down the standing situation. And rather than answer the standing, because she knew she had no standing.
Oh, you're speaking of one of the appealing parties?
Yes.
Okay.
She immediately got into her argument for the trees. And I think that's what bothered me, is we spent all that time and let her speak her piece before we talked about her standing. And so when we finally dismissed her appeal because of non-standing, we had spent a lot of time listening to what we didn't need to listen to. And so my question is, and I think that's what you're getting at too, is there a way that we could have gotten directly to the standing issue first, and then if they didn't have standing, it's all over and done with, instead of spending an hour and a half?
I think you all tried to handle the proceeding in that sequence. It just seemed to get derailed over and over. So, you know, yes, if I recall correctly, you all did address the motions, and ultimately you decided to grant the motion that had been asserted by staff's attorney, Kia Johnson, to dismiss based on standing. But that's what was presented. I guess initially you addressed the intervening party and admitted them, and then went into the motions to dismiss. So yes, I think procedurally that was reasonable.
It just didn't go smoothly.
It just seemed to be, you know,
Yeah. So you think that
Derailed.
the procedure was okay, it just
yes.
was rather messy? I mean, we couldn't, I, as a board member, couldn't stop her from talking. And so I think several of the other board members couldn't either. And so we just felt, let the conversation go on, and then we'll get back to the standing situation.
Yes. So, you know, it makes sense to address the standing issue first, because obviously if a party doesn't have standing, then you don't need to address the merits of their argument. So that's, I think, what the board was trying to accomplish and ultimately did. But to address Mr. Godwin's concern, I don't know that there's a way to prevent an
Well-
intervening party from filing something with the clerk before the hearing. But if they do, you as an individual may or may not wish to consider that before the hearing. If you think that procedurally they should first request by an ore tennis motion to intervene at the hearing.
Or, I don't mind them filing their motions, provided including in it is a request to become an intervener.
Well, and
If that happened, then I wouldn't have any problems with the filing.
sure.
I mean, it's just
I'm
the
not defending-
presumption, I thought it was presumptuous to come before us, start arguing or attempting to arguing your position, and you are not legally a party to this proceeding. And I think it was disrespectful to the board.
Well, again, I'm certainly not defending the intervening party's action or their attorney's motions. There aren't any rules fleshed out for that circumstance in the Land Development Code, and it's a very rare circumstance, so.
But you feel strongly that it's the board's responsibility, not the staff's, to let that appeal process start, and us to,
The appeal process well,
well, not the appeal process, but responding to the appeal. Whether we're going to accept it.
you mean
or-
the request to intervene?
Yeah.
Yes, that is that's not a decision staff can make.
And again, this is not a knock on staff. It really isn't. That case was kind of unusual from a whole lot of aspects, and I think that we're very fortunate to have the staff we do have, and I think they try to do the best they can under the circumstances. So this is, and I don't want this to be interpreted in any way to be a criticism of anything the staff did. It's not. They are, in my book, we are very fortunate in this county to have the quality of leadership and expertise that we do. And so that's not a knock on them by any stretch. It's simply, I guess it's just the lawyer in me, because it really, I thought, was improper at the get-go. And you know, it worked itself out, but, well, anyway, I just think that maybe we probably will never see that again, but I just felt like it needed to go on.
Mr. Godwin, and I do appreciate you for your remarks, and we respect you. We respect this board as well. We respect all our boards, along with the attorneys and our county and our assistant county administrator. This is the thing, I got an inkling, I got a strong inkling that we're gonna have another appeal, not on this issue. I got a strong inkling from what I'm hearing on another, that you all will be having another appeal. So, again, if that is a concern from this board, I strongly ask that maybe the attorney for the board can get with, that y'all can continue to work it out with her. So if that's the desire, because I know we have more parties who are gonna wanna intervene, I can tell you right now. this big group probably gonna be coming up soon. So we just need to be clear, either y'all want that to happen or not, so when it happens, they say, well, we can't do it because y'all had a long discussion about this and this and this and this and it causes more delay and disruption on the process at the beginning. Because I'm quite certain there possibility will be more appeals coming.
Well, hopefully, the board will be better prepared to deal with it, but I'm not sure in that instance that there's any other way we could have handled it, other than escort her out of the building. She was gonna talk whether we wanted her to or not, so we decided to let her talk.
What crossed my mind about all those comments that applicant made was, could we just cut the mic and take a 10-minute break or something like that?
Yes, the chairman can direct the tone of the meeting. And if there are disruptions, then the chair can decide when it's appropriate to stop the hearing. And we also have a security guard on the premises if you feel the need to have security come in and take charge. So.
Can the chairman do that? Or
Yes.
does the board need to make a motion to do it?
I think the chairman has the discretion, but if you wish to raise that, during the course of a meeting, then you can certainly voice that concern, and if you all want to vote on it, you can do that too.
Okay.
I just want to add to that, there's been times, before, like when it gets kind of, too much noise in the room. There's been times when I have respectfully, asked for him to quiet down, and I'll look at the chairman, and he'll tone it down or whatever. So, as long as everything is done with respect, the chairman has never had a problem with, dealing with issues like that. So, there's a lot going on, a lot of times. And the chairman, he's doing the best he can to not get beat up by us or beat up by them. So, sometimes you can, there's been times where, I'm like, hey, it's just too much, no talking, just wait your turn. And I'll look at the chairman, and he'll take it from there. So, we're not on pins and needles up here. It's just common sense. If someone's being disrespectful, they can be called out, but just be respectful when you do call them out, But the chairman, he's done a good job with that, I'm not familiar with the situation y'all talking about, due to my absence, but I've seen it before, and but it, like she says, a security guard, he's right outside the door, so everything can be done respectfully, basically.
Right.
I think we tend to try to give those people an opportunity to express their desires and hopefully leave better satisfied. This particular case where there was no respect for Robert's Rules of Order, no respect for this board, no respect for staff, that was their intent to begin with. They came to disrupt, and that's kind of what they did, but ultimately, I think the bottom line worked out to the advantage of everybody. And I doubt if we'll see anything like it again unless that there is an appeal and that same group makes their appeal, then I think we'll be better prepared to handle it at that time. And I think it is up to the board and the chair. Any other comments? Kind of got a general direction of where we'd go, Mr. Godwin?
No, I think that covers it. And again, I know all of us appreciate what the board, what the staff does to try to help the board. And we appreciate the legal advice that we're given to try to keep us out of the ditch. And again, anything that I've said, I just want to reiterate. It's not a knock on the staff because, you know, one of the things I've noticed about some of these hearings we've had is that we come up with the finding, or the staff comes up with the findings, and then we get into it and we ask questions about whatever. And then I've always said, and I believe it now, and I always will, that the staff can only deal in information that's given to them. You know, they can only do the best they can with what they get, and they can't do more than that. And I think that we, at least I, always try to keep that in mind. I know I ask a lot of questions and some to the staff members, but whenever I do, it's with the understanding that, you know, they can't make up stuff, that they do the best they can with the information that they get, and often the information they get is pretty scanty sometimes. So we shouldn't, in my opinion, we should never in any way think that they're not doing you know, trying to do the best product they can do.
Anytime there's a live oak tree involved, it's a serious consideration that we tried to respect, and I think it turned out as well as could be expected under the circumstances. Be prepared for future. It hasn't happened in the last 15 years, a meeting like we had, and it was just because their goal was to disrupt. Anybody else?
Well, Mr. Chairman, do we have any coming attractions for next month?
Next month should just be, as far as I have right now, is one conditional use and one variance.
Okay.
Next meeting is November 17th, I believe.
Yes, sir.
Okay, November 17th. Any other business to come before this board? If not, we stand adjourned.